things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you! You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is...
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
Welcome, everybody. This is Tyler Yonke, LPR, episode, 181. We're on the Nick Brigade. Continue. I hope everyone can hear me out there. Let me know if you can or you can't. There's already chat going on, so we will take a look at that. I got a cat on my feet here. My wife loves animals, so we have dogs, cats, chickens, everything you can imagine. Not everything you can imagine, but let's start. JC starts off with, oh, hi. Oh my God, hi, and smile and be happy. I can't read. It's been a rough day. Counselor, Northside, California, 707 says, what do you charge for an amicus brief filing? Now, are you talking about if I draft one or if I file it? If I just file it, the court, it depends what the court, if it's initial filing, it wouldn't do that on an amicus brief, $435 court fee. $60. I don't know what they're charging me to file. Are you asking if you want to retain me? He says retainer, whatever, to do this. I don't know what you're, friends of the court brief, you're not party of the case and you do this. I do family law. I try to stick to that somewhat. Okay, we'll talk about that today because here we are in the middle of the Nick stuff. Once again, I was looking through my old episodes and it was just like Nick. And I was like, oh, man, at some point you got to move on. But there's too much here. There's too much here for us. So let's take a look here at what some people are saying. And by the way, I've been so busy at work. Here's my deal. I was planning on being out of town tomorrow. That's why this is on Thursday, not Friday. And you're going to go up with some friends up to Lake Tahoe, got a place up there, ride bikes, hang on the boat, have some fun. And then I'm just like so busy. You do it, file an extension for your business taxes. They're coming due. So I'm like trying to get stuff together for that. My daughter had an issue with her car a few months ago, and I finally bought a new fender because I'm this, I'm going to fix it guy. Bought the fender. She's been out of town, and I've been trying to put this thing together. And those liner clips, there could be a problem. So she's coming back. So I got to get this stuff done. I've got to get all these things done. And here we go. Mark Gatto is here. He says, hi. That was for JC. Okay. Mark says, oof. Joe had a bad day yesterday. Are you talking about Joe Neerman? And I did watch some of his stream. We were going to talk about all this. I think if you really want to break down the motion, we talked about it last time, the motion to dismiss, the motion to quash. I had not read it. I still haven't actually read it, okay, but I've listened to a bunch of people. And then I played you clips last week of Nick Rekieta. And by the way, hello, everybody. I'm Tyler Yonke. I'm a family law attorney in Northern California. I also talk on the internet. Sometimes I just do it for fun. I absolutely love doing this kind of stuff. I grew up watching talk radio, and I love doing this kind of stuff, being able to pontificate myself, and I enjoy the chat going on here, so and do engage with all you guys. So with that in mind, this motion to dismiss, this motion to quash, people raked it over the coals, said it was shitty. I played clips last week of Nick where he's like, people, I don't write these. This is not me that writes this. Why would I hire an attorney and do it? That would be negligent on your attorney's part. And then he says, we prefaced it by saying, oh, by the way, if you look in this county, there's someone who's written this. And so he's like, I'm like, did you write it? Now you're taking credit for it. Now you're not. I don't know. You're kind of that kind of person. So with that in mind, there was like some issues that he had. I'm like, okay, he's got some points. Okay. And then you watch Kurt of In Civil Law break it down. And then Joe Neerman tries to break it down as well. And I don't know, Joe seemed to have sided with Kurt a lot. And with that in mind, that's a little detrimental. And I think that the issue is here with the motion, it's confusing. It wasn't well done. And so then, therefore, the analysis is sometimes difficult because we're taking these off of, here's how the typical, we're not in that county. We're not before that judge. We don't have all the evidence that we need to make these assessments, but we do have documents and you can go off of what's being filed. And so someone files something and you go, this seems kind of shitty. And then you have the transcripts, which we do have, and it also seems somewhat shitty, but, so there you go. And by the way, okay, I'm getting ahead of myself. Hi guys, yep, loud and clear, good. I should have checked that earlier when I asked and then rambled for 6 minutes. Good morning, okay. Aaron Imolte has been arrested for revenge porn, apparently. Oh, okay. Yeah, so people... Aaron was in the clear, and then that thing, he got all excited and he was sharing and stuff. People, calm the F down. I mean, just don't do stupid shit. And by the way, I don't care. Look, this is the problem with Barnes, right? And we'll get into his Jake and the Fat Man analysis here in a little bit, but if you don't know, I played the clip at the open. It's a crime show from the 80s. This guy was literally called the Fat Man, and he looks just like Barnes. And so, if you want to make fun of someone's looks, go ahead. I only do that because he and Viva Fry have gone over the top with their ad hominem attacks, which are just ridiculous. He did that again the other day, and he says, and we're going to play the clip, so maybe we'll go from there. So, revenge porn, don't do stupid shit. Just don't do it. Nick ratted on him. Yeah, it's okay. I mean, I don't even want to get into this. Imolte has a warrant out for revenge porn. These people, Friday is already based. Yeah, I was talking to Nearman. Yeah, okay, I figured so. Max has a hard time with names of so many degenerates, too much memory. So much easier to abbreviate. Nick equals Nick R, easy to remember too. Nick R is Nick R, does Nick R, Nicker. Okay, octopus web. I don't understand all that, but hi Max. Welcome. You're late, but you haven't got behind on much, Dwayne, because that's how I roll. All right. So we had an omnibus hearing. Man, last week we played some clips of Nick talking about that, how you bitches don't know shit. And, this thing went my way. And, of course, if you knew anything, you would know. Okay. And then you get the transcript and it's like, it's not quite what you say, Nick, but we'll go down there. So I'm wondering if we should... we also have April's motion to dismiss, Nick's motion to dismiss, and the omnibus transcript. I think, you guys, what should we do first? Omnibus transcript or the Barnes Viva Fry talking about the omnibus? Because you can read the transcript. Maybe we should read the transcript and then we can go and play the clip of them talking about it and see if those match. See if those tips touch correctly. Okay. All righty. Let's add this to the screen because that's how we do it here. Let's see. Window or entire screen. Oh, we better do window. There we go. Bum, bum, bum. Okay. Do we want to do... There we go. Omnibus hearing. And finally got a good transcript. By the way, I haven't read this, so if there's stuff I need to redact, whoops, I'll try to get it off the screen right away and get past it. But I don't think so. Appearances: Christian Pierce, Jordan Engler, assistant county attorneys appeared on behalf of the plaintiff. Francis, I think was Pierce also in the CPS case? I think Francis White, attorney at law, appeared on behalf of the defendant. Nick Rekieta, the defendant, was personally present. Good for him. Whereupon the following proceedings were duly had. I don't know why every time when they talk court stuff and you file stuff, it's got to sound so gay. All in Queen's English type of stuff. And by the way, I know there's conflict about drunk. I don't get drunk on stream, so I do have a drink every once in a while. Usually just to make sure I get. This is gonna sound horrible. I get a little phlegmy, so I gotta clear out, and I need something to drink. Okay, and it's been a long day. It's a horrible excuse. The court will call court file the state and 34 CR 24-341 State of Minnesota versus Nicholas Rekieta, who does appear with attorney Francis White. And by the way, I found this on other, and I'll just take it for what it is. Go Google this stuff yourself. Evidently, this Francis White attorney, and Barnes is going to talk about him as like he's in our local jury. He's a locals payer subscriber to Barnes. That's how they found him. Maybe he's a good attorney. I mean, you know, I pay for any locals? Tower King, which I'm the producer of. So no, that's the only one. All right. My cat's making noise in there. The matter is set for an omnibus hearing here today. Mr. White, did you have some contested issues today? Wait. In that clip, however, for the sake of an example of an on-Hamilton attack, Nate uses Barnes, old, no kids, no wife, known to travel, hint, hint, sudden permanent image of a gay. Barnes can't be erased. So you're talking about Nate. I heard Barnes saying that about Nate. And by the way, I'll just say Nate, the lawyer guy, some of his breakdowns are the best. And the reason I say that is he worked for years as a criminal attorney and then a DA. And here's the problem with the Barnes stuff, which is Barnes presents things from I would say, semi-libertarian professor perspective, right? But he doesn't talk about the real world implications for a lot of these things. And that's the problem here, where Nate is like, here's the shit. Here's how it's breaking down. You may not like it, but da-da-da-da-da. And I think that's a good analysis, right? For the most part, we're up here kind of saying things. That's what I try to do with the family law stuff, is to tell you, it's not how I want it to be, it's how it is, okay? So as an example, we're going to talk about stuff in plain view, the plain view doctrine, the Horton case. There's even a Minnesota case on point with that as well. And there's case law about, because Barnes talks about a general warrant. Well, okay, but there's case law that's encapsulated this stuff, and it's just shitty the way it is. I don't like it. You may not like it. Barnes obviously doesn't like it. But Barnes, stop acting like it's not, precedent in the law. I mean, we can change it. I don't have a problem with that. Let's talk about the realities of this case. Okay. And also Nate was a cop as well. Yeah. Yeah, well, I'm not a fan of that, but, whatever. Ignore Max. He's a crazy person. Okay. Just kidding. Okay. They had a search warrant for personal use. My opinion, massive overreach. Okay, we'll talk about that. Smile and be happy. Okay, let's just walk through this. And by the way, this is why you do go through these motions and motions, right? And the motions of trying to get this stuff and what we're doing here, but then filing motions to try to get stuff quashed and kicked out of court as well. Because there is overreach. And by the way, Miranda, all these different cases, these are specifically, it's not always the best persons that you're talking about. The court comes up with a lot of precedent because of shitty people, but that's to make protections. And I will say about this, if it does get kicked out, it's on the police not for lying necessarily, because I don't think that's necessarily the case. I think for being shitty in their job. And do you forgive them because they're not attorneys? They don't necessarily. Yes, at some point you're like, that's why we wear body cam footage. That's why we do these other things so that you don't get away with dumb shit. And I get that. I got to hold people accountable and whatnot. Too much going on. Kandiyohi County is going to have to increase staffing. Yep. Okay. I'll be right back to the chat. Let me focus over on this document. Let's get through this. Otherwise, as people claimed here, your ADHD, Tyler, is kicking. And I talk fast. I don't know if that's it. Yes, Your Honor, we do have some contested issues, said Mr. White, the court. Okay, I would ask that you remain seated, bitch. Oh, no, he didn't say that. Since we can pick you up on the mic, much better. Okay, this is a fascinating thing here, okay? So I'd see this. There's usually a table. This, depends. The plaintiff, the defendant, or in our case, the petitioner and respondent. And you come up there and there's chairs and you sit down. A lot of old school attorneys just stand and they stay standing, and then times, and I don't. I mean, is it dishonorable to the judge? No, because the judge will tell you, sit the fuck down. That's exactly what's happening here. He's going up there, he's remaining standing and I don't know that the judges care at all anymore because there's chairs. So they usually tell you come up there and there's a fucking microphone. So I've had this case many times, and it seems like the older attorneys are ones that think that, because I'll sit down and they'll look over and they're like, I'm going to stay standing. And then they look like, and you're like, okay, but I'm in front of this judge all the time. No one fucking stands. And they remain standing. And finally the judge is like, have a seat. And it's almost demeaning, like, which happens here. So anyway, just giving you some context of that. Hey, there's a microphone, motherfucker. There's a chair there as well. Don't be an idiot and stay standing. We don't really care to look at your belt buckle. Let's keep going. No problem, Your Honor. Yes, Your Honor. If I may it please the court. On Sunday, we filed a motion asking. Okay, so Sunday. This is August 21. Let me. I'm going to do something here, folks. You're just going to have to do it behind the scenes. We're going to look at the day of the week here. Oops, that's the wrong one. Where is my, okay, we'll do this one here. I'm going to pull up my calendar and I'm going to look back for, because I don't know what day it is. Did they say it? Maybe. Well, I'm going to look here specifically as, let me see, it does say it's August 21. I don't know why I'm being so particular on some of these things here. It's filed on 8/26, but it's 8/21. Okay, so we have 8/21 was a Wednesday, okay? And they said they filed it on Sunday, the 18th. Is that right? Is the 18th? 19th was Monday, 18th. Okay, so in a matter of no problem. So we filed a motion asking for this court to strike all evidence on Sunday. So this is Wednesday. Court's closed on Sunday. They filed it on Sunday. Then they have a Monday, Tuesday. And by the way, typically, if you're filing like a supplemental declaration, this is in family court, under civil procedures in California, you have to file it. I was just in court on Monday. I filed it 5 days, which was our limit there with the court. Opposing party files one the next day. The court's like, see this here? I got it, but I'm not reading it because it's too late. Unless opposing counsel, you want it? And I said, no, I don't want to have you read it. Okay, I'm not taking this. Now, you can talk to me, but I'm not taking this into account. The point is, you've got to give everyone time to read the documents. Now, usually they have, it's a shorter order here, so whatever. Keep that in mind, because I think it was Nick that made some comments like, you know what? This motion was so damning, and we did such a good job in court that they asked to draft a response and file a brief. And they don't do that unless they are really in trouble. Like, okay, look, you filed it on Sunday. They might not have even looked at it until Tuesday before. And it's like, you got to give us time. Okay. And plus you're going to definitely follow. And so just take that into account. Okay. We filed this motion to suppress all the evidence that was collected and under the warrant. And now Nick also said, hang on, what's going on with my, am I here? Why am I blanking out on everybody? Hello? All right. Okay, I'm back. I guess that was a bit weird. I don't know what happened there. Sunday, we filed a motion asking for this court to strike all the evidence, to suppress all evidence that was collected under the warrant. We based our motion on a two-pronged test that is in Frank's. Actually, I think Frank's is a three-pronged test, a case of which I am sure the court is very familiar. Frank's may be a two-prong. The three-prong is the plain view under Horton. My bad. A case of which I'm very sure the court is very familiar. Under Frank's, there's a requirement that the statement that was made by the reporting officer was false or in reckless disregard. Disregard. Okay, which one does he want? Of the truth, and that the statement was material. As I indicated in the motion that we filed, I believe that both of the legs upon which Deputy Pumplin, I believe is his name, based his motion or based his request to the court. I believe both of those are faulty. As I pointed out in the first in the first instance in the first, what did he belching or something? Since maybe he should have stayed standing so the mic doesn't pick him up. For the warrant, he based that on hearsay, which I concede is admissible. But hearsay from a reporting official a mandatory reporter who reported something to another officer, to that other officer, Sergeant Nestor, forwarded that information to Kandiyohi County Health and Human Services, and CPS rejected that. The letter that I submitted as an exhibit in MNDS clearly shows that wow, that's four that's. First, it's five that's with a first in between there. Particular artifice was rejected by Kandiyohi County, but even if it hadn't been rejected, the plain language of what is alleged in Deputy Pumplin's request, his application, doesn't rise to the level of anything to do with drugs. Child endangerment, perhaps. How are the kids endangered? This is not a good tourney right now. You don't give away. How are they endangered if not because of the drugs? The dirty clothes? Okay. That language in there reflects nothing but child endangerment at best. There you go. Okay. Well, do you get a warrant to come and search the house for the reason they're endangered? What are they endangered for? And I won't even concede that it does. Okay. The second element is that okay, let's go back here. So evidently there was a CPS report prior, and it had been closed out. It had been basically unsubstantiated. I don't know what they have there. We have substantiated, unsubstantiated, and founded as degrees from CPS. I don't know but they evaluated it out somehow. Now I don't know. And he said you didn't include it in the warrant application, that there was this rejection. Okay, I don't know if you have to include everything. Now, is that material? I guess the question would be, at what time was that report from CPS closed? And then this other information. So would the CPS close? And then you had this additional information, which seems to be like pastors and people at the church complaining about Nick, teachers saying dirty kids, da da da. If that's after it, where you're like, okay, well, this was at this point and this went above and beyond. And so I don't really know that this closes off. Does it? It doesn't mean much at that point. And so do you have to include it? Maybe, but you're getting your warrant based on all this additional information. So perhaps not, but this is what Joe was talking about, Neerman, last night, which is, okay, the standard for getting a search warrant is totality of the evidence. Okay. Totality of the circumstances, which is this little microcut and this little microcut, all of them added together, driving drunk, supposedly, dirty house, drunk on stream, perhaps needle marks, appearance of poly drugs, a threesome, a foursome, the church saying he's got, going out of church early, friends at church saying he's acting weird. He comes, sleepy and then comes back attentive. The kids not having clean clothes. You add all that up. Now you've got something that the totality of the circumstances is all there. So Joe's saying, okay, that's nice, but it's also breaks both ways, which is probably like Nick breaks both ways, which is that now you can crap this thing out by piece. If you get this little issue microcut as far as like he lied about this, he didn't include this CPS report, that starts to funnel itself as well. And perhaps with this information, it would have taken some of the effect off the totality of the circumstances. Now he mentioned here hearsay. Fuck you, dude. Here, I know you argue everything you can, but hearsay is a statement made out of court, made for the truth of the matter asserted. There's exceptions to hearsay all over the point. This is not a trier of fact. You are not talking about hearsay. You are, because that's what informants are. And this is just credible, plausible evidence that might lead to discoverable evidence. Okay. That's really what we have here. The second element is that the defendant Pomplin said that he had watched a video on the Steel Toe morning show by a gentleman by the name of Aaron Immolde, now a revenge porn purveyor. Aaron Immolde and the defendant have had I don't want to say a long-standing feud, long-standing Eiffel Tower perhaps, but not. But it's gone on for a few months. They were stooping the same women, and they were also living in the same house, which I think it said in that the affidavit. They don't like each other. They plain old just don't like each other. And from the writing in the particular application, it seems as if that the deputy identified Mr. Immolde as his expectation. They're almost as a concerned citizen. Well, okay. And some of these things the judge is going to have to take into account. Is labeling him as a concerned citizen rather than a mutual cuckold, is that basis for saying that he made stuff up? We'll see. Well, case law is, and very adamant that it doesn't qualify as a concerned citizen, because when you're dealing with a concerned citizen analysis, you have to look at what the motivation is. The motivation is important to determining whether someone is a concerned citizen or not. Okay. It depends on how much weight was deemed on the concerned citizen over some of the other reports, right? The pastor, because that came out. I don't know that Imholte is like, look, I've been in the house. He dropped a vial of a bullet out of his pants with, where my 1-year-old, 2-year-old child was on the floor and it had Coke on it. We did Coke together. We had all these relationships. Yeah, I don't like him now because he's banging my wife and we're going through a divorce. So you say this as a concerned citizen. I don't know why he called him that. But anyway, that's on the police officer. This once again, and I don't know if it's a police officer's just innate decisions and wanting to lie, but that's always concerning to me because I see it way too often. And so anyway, the motivation is important to determine whether someone is a concerned citizen or not. Also, the video. And it is stated in the video that is, he watched could not have been the defendants. In fact, the evidence that we received in discovery in their supplement one, shows a clip from presumably the video that he watched showing that it came from a different platform. By the way, I've told you, that video is still in its entirety from Nick's webcam to a platform under Nick's name as Odyssey. It is currently there. He took it down or privated it on YouTube, he privated it on Rumble, but it is still there on Odyssey. And someone needs to get to Pomplano or whatever the guy's name and say, you saw it on Rumble. Quick, go there. Let's get back to some of these chats here. Okay. Nate was a cop as well. Ignore Max. Okay. They had a search warrant. Too much going on. Okay. I think this is where we start. Bro, the old attorneys never get it in that need to speak into the mic, which is a desk. You need to sit, old man. Yeah. No does. Oh, no's. I did break Max. Oh, sorry, guys. Yeah, Wednesday. Thank you. Sorry, I'm focusing on this. I need to do both in the chat. I need a help maybe. Anytime weapons are found along with drugs, there sees plenty of precedent to back that up. Absolutely. We'll talk about that. Listen on my iPad. I'm playing through the speakers. Okay, get yours. Get them done, Max. Gotcha. I need to pick on someone else. Crime discovered incident to a search warrant. Need no further warrants. Yeah, we'll talk about that. Fourth Amendment, also that. Why do you keep getting shit autoplayed? Why do I keep getting this shit autoplayed? Thank you, guys. Thank you, autoplay. Glad you're getting my info. The little girl did cocaine. She was fine. We don't know, actually. I don't know what happened there. That's one. Nick is good about saying, hey, this definitive. I have my kids back. Obviously, there wasn't cocaine. I don't know. Let's see the ruling and all the transcripts from that the time that you got the kids back ordered. Okay. The plain sight doctrine applies when warrants are being discharged. Yes, we'll talk about that. Okay. You guys are doing that. You guys are talking about warrants. We'll get there. Don't get ahead of yourself too much. Okay. And that same 4-hour video timestamp match one. Yeah, that's what's interesting. Thanks, Max, for pointing that out. So I read that part last week of the affiant's declaration, which is the officers, and he talks about that. So it's interesting because he says in 2 hours, whatever minutes of this happened, and then he says this. So I don't know where he got those timestamps. Someone could have, because shared it and said, oh, it's here. Maybe he got a downloaded version somewhere. We don't know. Let's get back to this shit, though. Shows a clip from the presumably video that he watched showing that it came from a different platform. So the video in and of itself is not reliable evidence. See, this is where it goes off the rails because there was these arguments about reliable evidence. People have shot that down. I believe there's, when you go to court and you're going to go to trial over this, yeah, you got to have, reliable evidence. They'll subpoena those documents to get it. But for the warrant, that's not what we're talking about here. And so Nick was saying last week, he goes, you guys have this all wrong. We're talking about the confrontation clause. We're talking about some other things. I'm talking about him lying about this video And yeah, he could go watch it. He could have just said he saw it on Rumble. He saw it on Odyssey, okay? But that's not really what his attorney is arguing here. It's my belief that the Judge Fisher had known that the allegations that were made had been evaluated and dismissed, and that the video that Defective Pumplin reviewed was not Mr. Rekieta's video, but it was, in fact, a video that someone else had copied and then added elements to, which was a watermark, I think. So she would not have issued that warrant. Okay, see, and that's different than what Nick said. Nick said he's lying about where he got the video. We can prove that, and therefore that's a lie. It's a material lie, and therefore you should be kicking this shit out. And this guy's saying he altered the video, and if she had known that he had altered the video, she never would have, because it was a she, signed the warrant. When the reality is, if you just say, I got it off of Cogs or Imholte's thing, I saw this, 5-minute section, this dude was blitzed out. But he does seem to be able to point back to that. Maybe he saw it on Odyssey. We'll see. He never would have signed the warrant. 4 minutes elapsed between the application and the warrant. Okay, who cares? That just means she took time to get a good pin. I assume that all judicial officers take their jobs and their responsibilities seriously, and in doing so, they rely on the officers of the law to be honest and fully forthright and forthcoming in their expressions to the court. I think this is the case that the material omissions that Detective Pomplin did not tell Judge Fisher about, which renders the warrant invalid. So that I have a few things here, which is I'm listening to this guy. He's making a complaint about the time frame from when she received the warrant to when she signed the warrant. I don't know that it was 4 minutes. Probably took longer to read that. Maybe not. Those aren't good arguments, okay? Now, he did file a brief. So you don't need to necessarily recite all the same evidence because the court has this written in there in the declarations. So you do try to hit the highlights, but he's hitting some lowlights, okay? And I would probably be referring to a few cases here, and I would be spitting out the facts, how they fall in line, and then you don't have a choice but to quash this thing. But he's not talking about that. One of the other issues that was raised, the fact that the warrant, even if the warrant is, and by the way, people, I'm on, go subscribe to this show on the podcast form. You can go walk around like Max is doing in his house, but you could listen to it at a different time. I know it's live now. It's best to watch it on the video, but you can also, check it out on a podcast form. We are there as well. And it's in the link if you need the description of the show. Even the warrant that is valid as to drugs. The police seized firearms, or alleged firearms, I should say, from Mr. Rekieta's residence. Those firearms aren't listed in the warrant. There's no indication that they're looking for firearms. This case law that I cited in my brief, and I won't go over it here, is pretty clear that even when something is in plain view, it has to be related to, substantially related to, or there has to be a nexus between the alleged offense for which the search warrant was granted and the seizure of an item that is not listed on there. What would be, there is no nexus here, and there's not substantially related to, there's no nexus here. The case law, that is pretty clear. I don't know about that. I mean, what's really a nexus between drugs and what? Hookers? You got April there. I mean, there is statutes in Minnesota about not being able to own a firearm when you have drugs. And I know there's a USC, I'm trying to remember the number. We talked about it with some of the gun cases that we've gone over, specific that you can't have, and do I like these laws? No, I don't, but they're there. Okay. There's no nexus. The third issue that I read that, and by the way, this is me reading the transcript. It's not me having talking problems. That's my own issues. Involves Ms. Imholte's statement to the officers after she had been Mirandized. There's been a lot of confusion about this, the court. I'm going to stop you there. That the third, see, and this is what Nick has also talked about. He talks about the confrontation, which makes sense. But that's not what they end up arguing here, and that's like I said, I'm giving him some of the leeway here. But then he's like, you guys don't fucking know what you're talking about. Go watch Kurt on civil law. You've probably watched it. Joe Neerman actually watches Kurt's breakdown and I think has to kind of side with him. So go check that out because he talks about that pretty good. I'm going to stop you there. That the third issue, the court does a judge. Isn't that more of a motion in limine? That would be reserved if the matter did get set for trial. Yeah, motion in limine is usually motions like to suppress evidence at trial, okay, or hearings. You usually draft them up, you submit, or you can do them orally. I'm not sure if that's proper to me at an omnibus stage to really, discuss the admissibility, since it's not a constitutional or a legal issue. It seems like more of a motion in limine than what you're suggesting. That was my initial thought, Your Honor. Okay. But the case that I cited, Sutter, seemed to ended up with the issue being harmless error because, and again, this is something I'm drawing from my research, and it's from Nick's research. It doesn't raised earlier. It doesn't state it explicitly because it wasn't raised early enough. Okay, so you're just covering his bases. So belt and suspenders, and this is an old dude, right? Belt and suspenders, Your Honor. I wanted to make sure he's standing up, doesn't know what a microphone is, belt and suspenders. Your Honor, I wanted to make sure that it is raised as early as possible. And the state has conceded. I'm sure Ms. Pierce will tell you that they will not use the body cam footage that I'm asking the court to preclude unless Ms. April Hamolte testifies. And why is that? We'll get there. Okay, says the court. Mr. White, thank you, Your Honor. All right. So summing up, the court says, the first issue then, essentially you're asking for a Frank's evidentiary hearing, and that you mentioned some items that you placed in the MDNES. Just one moment as I refer to those. That was, well, do you want to detail what your exhibits are? It looks like you have some video recordings, a document image, a letter from Family Services, the application for a search warrant, and another video. Does that sound correct, Mr. White? There are in there, I'll get rid of the two easiest ones to get rid of. There are in the body cam videos because Ms. Pierce is conceding that it's not necessary, and those relate solely to the third issue that I raised. Those are not particularly relevant. The other video is a copy that I personally downloaded to the Steel Toe Morning Steel Toe Morning Show from May 22. That was their morning show, not the evening show, because apparently there's an evening show as well. I downloaded that, and that video references to times that are in our motion. So did he get the video? Because that's the very next morning. And so Nick was too hammered from his late night coke thing to take those off the internet already. The application for a search warrant, of course, was to the court already that was for the ease of use. The letter that I referenced, Candy Ojai County Health and Human Services stated that they had an investigation, the report from May 16, and they found it wanting for any evidence of child abuse or neglect, which is a pretty low standard, Your Honor. So we have the date, the 16th. So, hang on. Let's see. No, that's a different one. That's a different one as well. The 16th. So I want to look this up. Let me see if I can do this. Where are we at here? Let's try to find the back here in the Nick docs. One of the first ones. That Nick one? Nope. Go to the next Nick one. Okay. I'm trying to see if we have a date of when the 5/16, when was the date for this? What'd they say it was? May 16th. And that's when they started talking to the Covenant Church person on the 16th. Okay, that's one time. Let's look at another one here. It was arranged that on 5/23 deputies would meet at a predetermined location and eventually to travel to Spicer to execute the search warrant. So, okay. That's another date. Search warrant. Here's the application for the search warrant. Is there a date on this one? 5/1. So he's talking, here you go, case background. On May 16th, they reached out, they got this report. He's got troubles. 5/22. did the blog. Okay, you know what? I already actually know the answer to this, which is, let's think about this. 516, he's upset that it's not included in the CPS letter of saying there was nothing, it wasn't included in the documents. However, as I asked before, when did this officer make a lot of this investigation? You had the CPS report. Maybe he did or did not know about it at the time. I don't know if he reached out to CPS. We'll have to dig further in the documents. But from 516, when the report was, the case letter was issued, through the date of when they actually executed the warrant, and 521, I think, was when Nick was banging around and snorting coke online. Those are the dates that he's doing additional evidence, getting evidence. Now, someone came to him on the 16th and said, this guy's got a problem, the same day that the CPS said, there's no problem. So I don't know if that, and by the way, I don't know if that it makes much difference, right? Maybe it does, maybe it doesn't. We will see. The PowerPoint presentation that is titled Rekieta Video.pptx, that is the PowerPoint presentation that Deputy Pomplin references in his supplemental report 1, which is also included, that he created from someone else's stream, not from Mr. Rekieta's stream, but from someone else's stream. And the Rekieta.png is a screenshot that is taken up from that stream. Okay, and I've already mentioned the supplemental report, but that I don't know if they get the video that Mr. Pomplin reviewed, if they get the actual video of him that he did. I think that's everything, Your Honor. What I'm saying is that the evidence is not the best evidence. Well, I don't know that it matters at this point, because the best evidence rule is, the original document, get a custodian of record in here, subpoena the document, the YouTube, Rumble, Odyssey, and have them send you a copy that's been uploaded directly to there. That's what we're talking about. Not copies of copies of copies, not with someone else's watermark on there. That's what they're talking about. But those are standards that you're using for trial. Those are not standards that you're using for drafting and getting a warrant. All right. Let's see if you guys have any other things. Okay. Max says, back for a second, does Nick's counsel not realize that this particular judge out of the 3 in the county is known for being particularly hard on cases that involve both drugs and children? Max, you might know more than me. I don't know that. Nick should. Sounds like a small county. He would know about that. Who knows of any of their heads? Max, he's a bald washer. Okay. Yeah. Search warrant virtually voids 4th Amendment. That's Nick's lawyer's argument. Okay. You don't have to convince me. What else you guys got? In that same 4-hour plus videos, timestamps match. Okay. I guess we already talked about that. How far back do I need to go? Just because Nick claims his 4-hour video is privated now doesn't mean it was privated at the time detective viewed and took notes, or with premium could have downloaded. Yeah, exactly. And that was my point. And I don't know, perhaps he did, because as you've indicated and I've indicated, it appears that and with the affiant's declaration, the officer, sounds like he was able to see the entire stream. I don't know. I could be wrong. Okay, you guys are just going off here. Microsoft PowerPoint, LOL. Yes. Okay. What I'm saying, it wasn't the original evidence, and Judge Fisher had an expectation that she would have been informed of that. No, I don't think so, because once again, you can use hearsay in a application for a search warrant. So, best evidence, you're not going to have the confrontation clause doesn't exist at that point. Detective Pomplin did not inform her of that. In fact, his application indicates he watched Mr. Rekieta's stream, and seeing that it was only suggested that there were drugs in the house. Then she had a duty to tell her that had been edited so that you could have evaluated that. All right, Mrs. Pierce, any objection to the court receiving those items? Your Honor, I would object to the validity of the Steel Toe Morning Show. The affidavit for the search warrant does indicate that they did review a video blog on 5/22/24 from Aaron Himolte. That there are, as Ms. Frances White says, there are multiples per day. I don't know if this is the one that was watched. I can't talk to the authenticity of the video. All right. Any further responses to that on that issue? Mr. White, Your Honor, we're not submitting it for the truth of the matter here. So I don't know that she objected on hearsay grounds. She just said, I don't know that that's the actual video in question. Okay. So as we've stated, there you can you want to submit documents for the truth. You know, someone said something and it's a hearsay, but there are exceptions to hearsay. Each state has their own. There's federal exceptions as well, and or you can say, I'm not submitting it for the truth. I'm submitting it for, you know, their mind, their state of mind, or you know, as impeachment or whatnot. We'll see what he says, but we're not really objecting for it as hearsay. She just said, I don't even know if that's the right video. Well, maybe we need to talk to the officer, as an indication that there was a different video than what he actually reviewed. But excuse me, that Detective Pomplin watched that show, and that show indicated that there was animosity between the two parties. If you grant us an evidentiary hearing, Your Honor, the Frank's evidentiary hearing, I will certainly be asking Detective Pomplin whether or not he watched that video or not. Yeah, so they just want to be able to get into the Frank's hearing at all. Because then you got your chance. You get, you know, pound him over the head and then hope the judge does it. And I think Kurt and, you know, Joe and these aren't readily ordered. You know, you don't just necessarily, because the standard is pretty low. So you don't just, I'm sorry, my thing's here. You don't just actually get Frank's hearings, evidentiary hearings very much, let alone, you know, a motion, a summons, an affidavit, a warrant quashed in the first place. When I did a little bit of civil criminal stuff before, there was a similar thing called a pitchus motion, in which is you submit to the court that you want the police records, all their internal documents for the police officers for their conduct. These just are never, we got a hearing and they're just never granted. We got it granted. We also got, then the court, but what he did was the judge is like, oh, look, I'm going to grant this. I'm going to take all this info and I'm going to review and then submit to you what I think is important. He did so. The DA dropped the case and then we won a settlement, a civil settlement. So that's how bad those officers were. But, and then I even had a law professor come up and say to one of my guys that was really doing the work on this, I was just tangentially working on it. I mean, I was working on it, but he had done all the heavy lifting. She came up to him and she's like, we never, and she does criminal all the time. She's like, we never get these. How'd you get this granted? And I'm like, well, they're scumbags. Anyway, Ms. Pierce, Your Honor, I would ask to be allowed to do a written response. Ms. Pierce said, all right, how much time? If I could have until 30th, Your Honor, that would be fine. August 30th. Your Honor, I would ask to be able to reply to the written response, and I would need an additional days to do that, said Mr. White. The court, no, any objection? Typically, this is your motion. I would have you file your submissions first and the state thereafter. My submissions, Your Honor, are already filed. All right. In light of that, I'll allow a reply brief then by September 6th. Okay. Thank you, Your Honor. It makes me think that the judge is just like kind of appeasing everybody because, you're right, he filed the initial request. Why do you get to keep going on to the reply? But it's what it is. All right, the court will take the matter under advisement as of September 6th to issue an order. Typically, an order will be provided within 30 days of that date. Was there anything else here today, Mr. White? No, Your Honor, except for Ms. Pierce saying on the record that she did agree that the third element would be that she agreed that there would be no use of the body cam footage unless Miss April Imolte testifies. Ms. Pierce, I agree that there would be, I cannot use April's statements unless she testifies because they're hearsay. Yeah. Now, once again, we talked about hearsay. We've talked about exceptions to the hearsay rule. And I think, you know, admissions of a party opponent, if she's in there, you can always use her statements if she's one of the charged people, but she's not. Or she is. I guess she did get charged. I'm not agreeing that I would, but she's not going to be necessarily a party in this case. I'm not agreeing that I would use it for any, I would not use any of the body camera. All right. Well, nevertheless, those items are motions in limine. You've noticed it. It's an issue for the matter that does go to, if it does go to trial. And if there's any further contest of that, we can certainly discuss that further as well. Okay. Mr. Understood, Your Honor. Thank you. The court. All right. Very well then. The court will take under advisement. All issue in order once briefing has been provided. We'll conclude the proceedings today. End of record. We're done with that. Okay. What I really want to do now is get to this Barnes stuff here because this was probably what we should have played right up. But anyway, now we have an understanding of what the Omnibus hearing really was about. Not much took place there. It was his Frank's motion, and they don't know if they're going to win it or not. Let's go to 1.25 for these fat fucks. I just say that. Okay, the 33 watching. Okay, good stuff here. Glad to have you guys on board. Aaron and Nick can join the woods. Okay, let's talk about these two yahoos real quick. So this Viva Fry and Robert Barnes. Now, Robert Barnes is going to take, let me just fix this here. This is Nick's favorite thing to do now, is to kind of mock practicing attorneys, right? He does this. Now, there are Sean, I don't know if a lot of these guys practice law anymore. I think Joe still does. But it doesn't mean they're wrong, okay? And I know part of this pushback is because people have mocked Nick because he's not a practicing attorney. But the reason they're doing that is because of his own conduct from the arrest forward, okay? When you're an attorney and you give advisements all the time and you're talking advice and you're doing, and he did do cases, I don't know, maybe it's, the preacher's kids are the most evil, the doctor's kids they're unhealthy, and attorneys just can't help themselves, their own worst enemy. Maybe that's the case. But he's talking, I just was reading here, April gets Mirandized. He does, and then he keeps talking, and he's talking, and it's just like, I don't know what the fuck you're doing. And he's made mistakes. He's talking up in court. I just don't, there's a lot of stuff you're just like, and so it makes you wonder how good of an attorney he actually is. Okay. That's part of it. And then he's coming over here and some of his arguments, that's some of it. So let's listen to these guys. They're going to break down the CPS and the whatnot.
So multiple aspects. So there are people that had certain factual conclusions about him that have been disproven by the fact that his kids have been returned to him.
Nope.
Which doesn't happen if all those factual allegations against him were true. That's part one. In this criminal case, a member of our board, a member of Rekieta's board, a member of some other boards, a good conscientious criminal defense lawyer, brought motions challenging.
A member of a board. It's a guy that pays, this is one of his local subscribers. No offense, JC, if JC was paying in here, or someone that gives a super chat, you'd be like, is a member of my board. You mean he's a friend of yours on YouTube? Yeah.
Challenging multiple aspects.
By the way, I want to talk here real quick, and I'll get through this. Barnes saying that if he was as he was, he would never have got his kids back. I don't believe that's true. As we saw over and over, they wanted him to do an assessment. He was supposed to get a patch. He was getting tested. And I'll say this outright, which is it depends on your station. It depends on what kind of person you are and what support you have around you, how much CPS tries to get the kids back. I just had a case where the CPS person was dynamite. He was like, I hate the woke people. It was all this stuff. And he was doing the best he could to help this dad and my client that was a good guy in the first place, but he was a good CPS. And then there's trashy ones. So it depends on what the arguments is. And just reading a lot of the transcripts there, the judge especially wanted the kids to get back, didn't want to necessarily have supervised visits. And if I started this when day one, we were talking about CPS. If you do this was Nick's problem, you got to do what you got to do to get your kids back, and not doing what you need to do may conflict with your criminal case. So he was bound up in that. But yeah, he don't say that. If Robert Barnes is saying here that Nick never did coke, all this stuff, that's bullshit. Because I'm saying this as a judgment on Rekieta. If this case gets pushed away, it doesn't mean that he didn't cuck himself. It didn't mean that he didn't have drugs around his kids. It didn't mean that the house wasn't messy. It just means that either they didn't prove it or they've decided that we're going a different route. That's all it means, Barnes. So don't give me this. We're not judging someone's moral character here. We're talking about the law, okay? So let's keep going.
The search and seizure.
And we don't know.
Fourth Amendment violations, Fifth and Sixth Amendment violations, and kind of a Second Amendment, Fourth Amendment hybrid violation. So the question is whether statements were coerced from witnesses in violation of their right to counsel and Miranda rights, whether or not the search was procured by fraud, and whether or not the execution of the search was overly broad. somebody might have mentioned these issues right at the very beginning of the case as staring out from the warrant.
Right. So filing a motion to have those suppressed doesn't mean you're right, Robert Barnes. It just means that someone filed all those things to have them reviewed. And look at Viva Fry over here. Oh yeah, you killed it, Robert. What happens, Robert? Because you inferred something here, which was the child issue, the CPS issue. Somehow that goes away, and therefore this guy filed a motion in criminal court. I'm right. It doesn't even make any sense.
And a bunch of the so-called practicing lawyers.
That's me.
On LawTube. By the way, if anybody practicing...
I'm not on LawTube. I'm just my own person.
Practicing lawyer on LawTube is giving the kind of advice these people are on the Rekieta case. Note to never hire them. The potentially criminal defense lawyer, the legal mindset that has very interesting travel patterns.
So the advice they kept giving was shut the fuck up, stop talking to the cops. That was a lot of advice. Get an attorney. Right? This was the advice we were getting. Most of these people on here are breaking down the analysis. They're not giving advice. You, Robert Barnes, were giving advice.
Nate the lawyer, go back to being a policeman, I think, or covering like women's soccer or something.
I think he was a DA. He was. I know he was a DA in New York City. He was also a cop. Okay, that's bad. He's a black guy too. You're gonna go after him for being black, Robert Barnes? He was also a criminal defense attorney. That means something. That's someone who's in the trenches all the time. What is Viva Fry's over here giggling? And what is he practicing? Is he practicing law? No, he's driving around in a car shirtless.
Uncivil law, God bless him. Stick to patent law, bro. Now, Good Logic's done great conscientious reviews. Don't always agree with him, but he's done very
well. Watch his last night, Robert Barnes.
Thorough, fair reviews. But most of LawTube has been utter crap on this. They made legal look sharp. That's how bad it's been. They made legal look sharp. So a little breakdown of this. So Rekieta's already won on the Fifth and Sixth Amendment issue. So
did you see him winning on the Fifth and Sixth Amendment issue? Anybody see that? The confrontation clause. Is that what we found that there was? No, they said it was a hearsay objection. But yes. And what is? I believe that her statements to the cops after she was Mirandized. I'm not sure about this. I believe they are talking about when his wife and she had said in jail that Nick said, oh, she's not our babysitter. And the other one said, oh, she is our babysitter or something like that. That might have been the conversation. I don't know that it even really matters, that's pertinent. But anyway, there we go.
I suspected. I was like, I bet they did a lot of illegal crap during this case because the whole thing screamed it. It was like a case like this normally doesn't progress like this, doesn't proceed like this, doesn't read like this. If you've been around enough of these cases, if you've studied enough of these cases, you knew there were sirens going off and red flags everywhere. And it wasn't Hail Marys or special defense of Nick Rekieta or anything else. It was just any case I would look at and say, this case smells like a crap case. So the government has already conceded. Prosecution has already conceded that, yeah, we kind of Mirandized one of the witnesses. And yeah, they kind of asked for an attorney. And yeah, we kind of had another cop coerced testimony out of him.
Okay. So once again, totally understand. But that's not where we're at. They didn't. By the way, the motion he did was a motion to suppress, a motion to quash. The Franks hearing has nothing to do with him Holte. That goes to trial, and that's a hearsay. They would have that if he didn't say anything. They would have a problem there if they try to use a. Once again, we are talking about the actual affidavit, the warrant. The warrant has nothing to do with what April said after the warrant was executed. So Robert Barnes, and you guys listen to the transcript. Nothing was won here by Robert Barnes.
So yeah, we can't put that on because he has confrontation clause rights that are independent. Some people think, oh,
and hearsay. It's a hearsay fucking problem.
Oh, unless it's your rights that are violated, you don't have standing. There's a whole bunch of circumstances, either through the confrontation clause or the due process clause, where you can find ways to raise third-party standing effective claims. Sure. That I won't go into all the intricacy of it. But there's a bunch of people that didn't understand that basic part. It's like, Lord have mercy.
I don't know about a bunch. I know that Kurt pushed back against that right away, but I think it was the way the motion was read. I was listening to it. Like I said, I haven't read Nick's motion on this one, except for the transcript here and what people have talked about. But once again, the motion itself was, hey, we don't want April's evidence. Yeah, it's a way. You saw the attorney there. He did a little sneaky. He's like, she's agreeing not to use the body cam footage. And she's like, well, I said at trial, I wouldn't use, her testimony because it's hearsay unless she's testifying. I ain't going to use the body cam footage still there, bitch.
The government conceded it. Didn't even fight it. Said, yep, no problem. Can't introduce those statements.
They conceded hearsay statements can't be used in court unless you have exceptions. That's exactly what they did, Robert Barnes. Evidence 101.
The next set of issues was, as I also kind of predicted, so there's two ways to measure a warrant when you're reviewing it. And this basic thing, a lot of these law tubers can't get, these practicing lawyers can't get. No wonder they have.
I wonder how Viva feels right now because he's not a practicing attorney, right? So, and I don't even know how much Robert practices.
Like no history of criminal case success.
Oh, I'm sorry. Barnes has a vest on and a tie. That means he is currently feeling the effects of being an attorney.
That anybody knows about. Which is, one is you assess the cop. Another is you assess the court. So, for example, when you're assessing whether or not there was probable cause for the warrant to issue, that is looking at what the judge did, with what the judge said and what the judge knew. And that's based on what the judge was told. And that can be, it's misinterpreted as a deferential standard. It's still a constitutional standard, still federal. You get language and lingo like that, but there's also language and lingo that goes the other way. But there's a different way to challenge the warrant. And it's what I said from the get-go, which is you can challenge whether the cop told the truth. It's it's loosely after Franks versus Delaware called a Franks hearing. What it is, you tell the judge, hey, judge, there was information the cop had access to that he failed to tell the judge, and that's how he got the warrant. Mm-hmm. And what's amazing is we don't even require, I think we should, but we don't require, we don't impose a negligence standard. So we don't say the cop with due diligence would have done boom, 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 boom. I think we should require that to meaningfully enforce the.
Okay, so once again, this is him being a professor. He wants to say what he wishes the law was, but that's not with the situation there in Minnesota. So let's keep going.
Fourth Amendment to the United States Constitution, but we don't. We just say, don't lie, don't make stuff up, don't hide stuff. But everything about what this cop did screamed to me from the very beginning, before I'd even read the search warrant affidavit, just looking at the detention warrant, screamed that this cop is a liar, this cop is a fraud. And you don't have to love Nick Rekieta to care about Nick Rekieta to see that. You just have to care about the Constitution of the United States of America.
Okay, I'm sorry. I'm sure you care about the Constitution, Robert Barnes, just not your own physical Constitution. Now, is that true? Is everything you read in there just screams that? No, it did not scream that. I'm sorry. Everyone's gone over this. You are a tool, and when you didn't have all the details. You read the detainment warrant detainment, not the affidavit, and that's when you said you're freaking out about it. It's all this stuff. I don't know. This is con Inc. When I mean conservative Inc. being a con, okay? Which is these two guys that love to do this, which is you stir your party up in one. You don't do any kind of real analysis of you just stir everybody up so that they come to your side. Then you can grift off of them. It's really
and have a little bit of practical lawyering experience.
Yeah.
And so
I don't know why Viva keeps laughing. He's literally mocking you. You just don't know it.
The cop lied about tons of stuff. So it turned out that Children's Protective Services had already told the cop what's being alleged does not constitute sufficient grounds to allege any kind of child abuse, least of all a crime.
Now, we don't know what the letter said. They just evaluated it out. So that's a bold statement there, a very declarative statement that he doesn't have any justification for, other than a letter was evaluated out. Now, as we just kind of broke down, just eagle's eye on this one, which is the letter was issued on the 16th of May, okay? That's when it was issued. I don't know when that report was closed. It could have been 2 weeks prior. The officer started a lot of his investigation on the 16th of May going forward. That's just what I'm able to tell. It appears to me, once again, we're shadow boxing here. We're trying to see stuff where it is, and it's hard to tell. So the definitive declarative statements by Barnes is a bit much, but just remember that. I don't know if that letter would have been dispositive to kick this thing, or she wouldn't have signed it, but everything that the officer did was letter and after, including the stream. The stream was the dangerous part, okay? The stream was the part that really turned things over. When I first saw that, before all this arrest stuff happened, I think I saw a clip of it the next day, and I was like, ugh, that's hard to watch. And I'm like, it's also why I've been watching for a while. Let's keep going.
You think he included that when he mentioned it to the court? He just kind of forgot to put that in it. The second thing, he knew that the weird dude up in Minneapolis had said all kinds of crazy stuff about Rekieta. He was citing him like he's a concerned citizen. And he just forgot to mention to the judge, actually, he's kind of a nut job, has been said.
Do we know that what Aaron said is wrong? I mean, concerned citizen or not, you do take these things differently. It's a testimony from an inmate, you know, the jailhouse snitch type of thing, or he just wants to get, he's a roommate, a cellie with this guy, and he wants to get out, he wants to cut a deal. I don't know that Aaron's cutting any deal. Now, he did have ulterior motives of like, maybe I'll stick it to them because he's stooping my wife. Granted, all that in mind, but I think this is what happened with the officer. And it could be a fucking liar. I don't know. Which is, this guy's telling me a lot of stuff and it's lining up with pastor. I mean, you're going to take on the pastor now? He will, probably.
Saying crazy stuff for 6 months about Rekieta.
I don't think it was
6 months. And then the third part was he claimed, remember the videotape where he could magically tell what was and wasn't white powder as opposed to what is a flash reflection? And he knew from his special video insight that must be cocaine. Extraordinary, even though all the behavior he then describes isn't consistent with taking cocaine. Which I said that screams BS off the plate. Well, of course, he didn't even get the original video. He lied about it. He said, oh yeah, I was watching the original video. No.
This is the problem with Barnes. We just broke this down. We don't know that he lied about it. Okay, we don't know. It could be true. By the way, I've seen some of that video. I can't tell if he has coke. I mean, it's grainy. It's like the coke on his face part seemed a bit much to me. Okay, maybe you have a point there. But I don't know what Barnes thinking that Nick was, what state he was in at that time and not to be concerned, right? I mean, Barnes is acting like he's watching Viva Fry over here, and I drew cocaine on him, and he's like, I don't even know how you could think that anything was. Maybe you're looking closely because this dude is a fucking train wreck on camera.
He didn't even download it. What he did is he saw somebody else talking about it on another video.
We don't know that for sure. That's the allegation. Please stop.
And this was disclosed. They discovered this going through the process. So he hid the fact that he watched somebody else's video of something. There's video of me out there with the people made AI memes of me saying,
okay, motherfucker, we're not talking about AI, okay? You're talking about a different clip of Nick. Are you telling me that the clip everyone saw is fake? Is that AI? This guy is fine, but here's the problem. He can't be truthful on a stream right now because he's defending Nick. Gotcha. That's perfectly fine. But you can't be truthful right now about something. And so I'm not going to believe you with anything. Everything this motherfucker says, I instantly say bullshit. And that's, you prove me wrong. I produce Tower Gang. I don't know if anybody watches this, but it's a great show. The guys on there, they send me clips and stuff that they think is funny. Clint, when he sends them, I rate him 1 to 5. When Clint sends it, I immediately put it at least a 4. That's the default. Then I watch it and I go, okay, maybe I'll downgrade it, upgrade it. If Clint says, discuss this, it's a 5 and we're doing it. If Toad sends something, I'm immediately putting it as a 2 and then I'll watch it and I'll like, oh shit, that is a 4. Or, that stays as a 2. It's the default. You are default 1 here, Robert Barnes. You're not funny. You're not good at this. And you lie too much of obvious stuff. And therefore, I can't take anything you say very seriously.
All kinds of crazy things. They have me as Breaking Bad.
Yes.
They have me as,
yes, you're Jake and the Fat Man. Everyone thinks
imagine
that's
some cop
you.
getting a warrant for my house because he watched that. And this guy, he lied about that. So what you request is what's called Frank's hearing.
What did you lie about too?
For my house because he watched that. And this guy, he lied about that. So what you request is what's called a Frank's hearing. And the prosecution, if they're worried or nervous that they might lose a Frank's hearing request, is they go in and they request, we need to have special briefing, judge, give us extra time, If they're confident, 90% of the time, they go into the court and say, nah, here's where they're wrong, boom, 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 let's move on. Instead, they go in front of the judge and like, we need extra briefing. Also, we need to figure out how we can try to pretend the cop didn't lie or try to get him to tell another lie, or I, the prosecutor, am thinking about how do I get out of this case. If a smart prosecutor uses this as an opportunity to get a plea deal on the table, to get a deal done.
Okay, so there you go. Remember what we said. He filed it on a Sunday. The court was on Wednesday. They don't have much time. And they're like, yeah, we'd like to actually file a response. Now, if his point is, hey, when you have a winning case, you don't file shit. It's like, who the fuck are you? The judge is taking it under advisement. Of course you're going to file something. The judge says, I'm having a hearing later to determine this. Do you want to file something? They're like, you know what? No. Oh my God. That is the dumbest thing I think I've ever heard. The judge wasn't making an order on this day. The DA didn't say, and by the way, we read this, right? Did you hear the DA say, wait, I want to make arguments about all this. I want to make arguments. Let's take some now. No, the judge is just like, okay, I'm going to take this advisement. You want to file something? Yeah, I'll file something. Oh, and if that's your point, Robert Barnes, if it was so strong, then in your mind, Mr. White, the attorney counsel for Robert Rekieta, Nicholas Rekieta, he would have said, you know what? I don't want a reply brief. I don't need one. You know why? Robert Barnes told me one thing, school of law, being an excellent litigator, which is when you know you've won because they don't want to argue it in court, you don't file anything. You just don't do it. Your Honor, I'm not filing it because spiking the fucking Coke football.
That's what a smart prosecutor does. 1 out of 3 cases in drug arrest cases is pled out before the Court of Appeals ever hears of the underlying search warrant issues. Right? 1 out of 3 gets outright dismissed. Right? So, I mean, this is the big issue legally in every case like this. But it turned out the cop was completely rogue. Lying, hiding information, fabricating facts, making up claims, intimidating, coercing other cops, intimidating, coercing witnesses in direct violation of their 5th and 6th Amendment rights. And then last but not least, they seized all the guns. Well, there's a little problem. There's no reference to guns in the warrant. The cops had been there at the home previously and had supposedly been following him as a regular follower on his video channel, so they knew he had guns, but they didn't request that the court to seize those. Why? Because they didn't have any evidence it was connected to any criminal activity. Why? Because it might trigger a red flag in a small rural county. Hold on a second. You want to go grab somebody's guns? What's going on here? So, but what do they do when they get there? They're like, yeah, we're just going to grab it. And they grab random stuff, by the way. Well, you know, there's a word for that, or phrase for it. It's called general warrant. And it's called, otherwise known as, for all the constitutionally illiterate practice.
I don't know why Viva Fry smiles like that. Like, oh shit. Did you hear that? Robert Barnes said general warrant. Oh, snap. Is that something you get at, Kung Pao restaurant, General's Chicken and General's Warrant? Oh, no. I don't know why he smiles like he just made some sort of snappy thing. Yeah, a fucking General Warrant. We don't have those, right? You have to have specificality in a warrant. But once again, Robert Barnes, we're going to talk about case law. Case law that's not in your realm, and we'll talk about a little bit of that. Let's see if he talks about
lawyers out there, unconstitutional. It's why the 4th Amendment exists. To get rid of general warrants. Now, here's how cops have been trying to get away with this for years. They get a specific warrant, say we're going to get this, and this. And then they go in and they say, oh, it's in plain view. I just saw it. Well, of course, that is basically, as courts started to figure out, hold on a second, that would be meaning you have a general warrant. I give you a warrant for something particular, but anything you see while you're in there you can take, that's a general warrant, which is exactly what the 4th Amendment is supposed to always prohibit. It has to be particular with what it describes as to what is searched and what is seized. And so that was problematic. They seized all the guns, charged them with things related to the guns. The problem is they had no basis to seize the guns. The guns weren't related to they knew about it beforehand, didn't even request its seizure, didn't get approval from the warrant, and it wasn't connected somehow. They didn't see, I see the gun connected to this somehow. That makes it a nexus to the underlying criminal activity that you're allowed to search in, because that's the limitation they impose on plain view, which means all of the gun-related charges have to be thrown in the enhancements. Yeah.
Once again, what would be his connection or his nexus? So, plain view. I was trying to find this out. Maybe Max or someone else can do this as well, which is, and by the way, you can only search where you think that drugs will be found. That's the problem Nick has here. That's a problem. Robert Barnes he doesn't like to argue both sides. It's his way, the highway, and then, Nick's way, Viva Fry's way. And you've got to argue this from both sides here, right? Which is, okay, plain view. The plain view doctrine, we've talked about, it comes from a case, Horton. And I'll read about it in just a second here to do a little thing. We got about 15 minutes left to go, I think. And with that in mind, you've got to argue plain view, which is they only search for drugs where you think drugs might be found. Okay, well, they're searching in the safe. They're searching in table. I don't know where the guns were found. This is on Nick's part. Okay, we'll talk about it. If they're like, hey, we found this in your daughter's, pantry. Okay, where is drugs not going to be found? Where are you not going to hide them? I don't know if these guns were in plain view or if they had to look for them. Presumably, they're under the bed. I don't know that they got all the guns. This would be part of interest for me, which is, did they get all the guns that Nick has or only the ones that they could find? And by the way, you can take things that are in, show evidence of a crime. If it's a nexus with this, drugs and guns go together like whores and, I don't know, Rekieta?
To be thrown out. So he's got robust constitutional issues. Now, who knows with the state trial court judge? 9 out of 10 are in the pocket of the prosecutor.
This is my favorite Robert Barnes thing, and it happened with Alex Jones and all that, which is he's got an amazing case. It's a drop-dead case. There would never be anything like this. And then he goes, but man, you know what the problem is? You got this one judge that is really going to be problematic. I don't know, this little county, they don't like who he is, and they're probably going to have a problem with this. So I'm just thinking at this point, he's going to probably lose because of this, which means your predictions are just fervor for the masses. God damn, he sucks.
And they're complete wusses and not willing to enforce the Constitution when it comes to these issues. So that there's always that issue. But if you're the prosecutor, do you really want to keep going forward on this case, which is for the cases you typically have at the bottom of the pile, frankly?
By the way, I would love for them to uphold the Constitution. The problem is Barnes himself probably wouldn't uphold the Constitution, which is the 14th Amendment, Robert Barnes, should it be incorporated? Should it incorporate the other amendments, the 14th Amendment for all these other ones? Should a state like Minnesota be able to make its own gun laws and a state like California make its own gun laws, like I believe they should, and not be upheld? Because the Second Amendment is not holden to the states, but the 14th Amendment is incorporated and such. The Constitution did not anticipate this. They explicitly were against this. That's why the Second Amendment wasn't incorporated until 2009, right? Right? So are you going to uphold the Constitution or the state Constitution? What do you want? What do you want?
Somebody like the party a lot, that's your big crime. I mean, come on. If you're a local prosecutor, you're dealing with real crimes. No, not this, minor stuff. So smart prosecutor dumps this case and doesn't have Fourth Amendment law that embarrasses the entire police department, embarrasses the entire prosecutor, potentially embarrasses the judge. That's what a smart prosecutor would do. But I don't know if they got a smart prosecutor up there.
Did they? But now I remember in the original charging documents, or at least when we got additional documents, it said that the way they got to the felony amount.
Okay, he's talking here. Let me go through it to you. I really appreciate the super chat, by the way, Oliver. Listening to Barnes talk fast is hilarious. It's all hilarious. I'm sorry, I've left a bunch of this stuff here. Someone said, LPR, do you understand the dispute between Barnes and versus LawTube? Does this very small rural county actions against Rekieta the normal reaction to the complaint, or did they go full stream SWAT team? One, they didn't go full SWAT because otherwise you would have had a problem. Matter of fact, we talked about, and I appreciate that, smile and be happy. And I don't know the reactions, right? But you're living in a small town. You're a complete asshole online all the time. I mean, Rekieta's defamation, I remember watching this when I was a fan of his, and I'm watching him talking about Montague or whatever the guy, the defamation case. And while he's talking about a case that he's being sued for defamation, he continues to reiterate the comments he's in trouble for or potentially in trouble for. And I'm just like, I don't understand. That's why I'm like, what is, I don't know. He talks then about all the, do you hear me mentioning any judges' names? Oh God, no. I mean, good Lord. And I live in a much bigger place than him. I would never be doing that. I'm in front of these people all the time. It's like professional respect, right? So you just don't do that. I mean, what do you poke the bear for this stuff? That's ridiculous. And no, I don't know the whole Barnes v. LawTube. I'm not pretty much into that. I've watched Nick Rekieta. I've watched these two assholes here, the Jake and the Fat Man. I've watched the other guys. I enjoy listening to stuff. The next shit came about, and now here I am. As Mark says, cope. That's what I do. Okay, if the cops raid my house for drug. Oh, by the way, let me go back to what you said here about the raid. Remember the raid? They came to the house. Someone else pulled Nick over. So they have cops at the house, multiple cars. They have a cop with Nick, and they go to the house. They knock. A girl comes to the door, says, "I'm not letting you in. Sorry, pigs. Step away." fine. I'm perfectly fine with daughter saying that. She didn't say pigs, but if my daughter said that, I'd be like, okay, that's how we taught him. They are then with Nick and they say, look, can you give us the code to the house? We're going to go in the house. Can you give us the code to the house? And he says, no, get a warrant. And they're like, well, we have a warrant. That's what we're executing is a warrant. And then they waited some time and then they busted down the house. Okay, it wasn't a SWAT raid in that ascent. It wasn't a SWAT raid in that instance. And it could have been done much easier. You didn't have to traumatize the kids by busting down the door. It's already this warrant's in a place. You're not going to fight it on the street there, Nick. So that's probably part of the issue. So I don't know if that's the case. Could very well be. But are you going to tell me, smile and be happy, are you going to tell me that the video, if you're a family member or you're a church member and you're seeing that remember when they got the kids as well, they picked up one of the kids, the Coke thing, I don't know what to say about that as far as on the kids. When they picked up the kids, they asked one of the daughters, do you need to go? We're going to take you someplace. Do you need clothes? And she said, or he said, I don't know. They go, yeah, I need clothes. I haven't changed in about 3 days. You're going to say, yeah, okay. My constitution. Okay. Let's keep going with this. And then we got to finish off here. Oh,
so the cocaine or whatever it was, 25 grams was by including the packaging. Have they reduced that or is there?
They added that. They have at some point they're going to have to reduce that dramatically as well. Yeah. So a lot of the charges are already coming off because his kids are already back.
Liar. Charges aren't coming off. His kid's coming back with him. He wasn't charged with child endangerment. That was a CPS issue where they took the kids. That's not charges coming off. That's a separate case. Okay. I know you're a practicing attorney, and Baldo over here, Viva Fry, he's your sideshow, and he may not know much about it. That's a different case. He got his kids back. Charges aren't coming off. The only thing that's coming off are your pants in a Las Vegas whorehouse.
Those claims are all crap. The guns should be thrown out, so that means that's all crap, and the enhancement's all crap. The measurement was always crap, so they have other issues. I'm sure there's probably other evidentiary defenses.
Maybe
the problem is the cop lied repeatedly to get the warrant.
Well, I don't know that he lied repeatedly, but we'll get there. We'll find that out, and if that's the case, I hope he goes down.
If you take out, so what's materiality? Materiality is, why did they put it in the warrant? This is how I always respond. When I've dealt with these issues in front of judges. Said, Judge, if it didn't matter to the warrant, then why was it in the warrant? Right? And so 9 times out of 10, if it's in the warrant, it's material to the warrant.
No offense, but you're talking about Barnes, who I think is a smart guy. Okay. Viva Fry. But you're talking about attorneys, okay, arguing stuff. What is in the warrant is not an attorney. It's a desk jockey police officer drafting something that he thinks is important. I just got something today from a client. It's this declaration, what she wants to do, and she wanted me to look it over before we formalize it and get some ground. And I'm looking at it and I'm like, okay, 4 or 5 pages. I probably reduced what you have down to 2. A lot of this, you're not going to talk about this other guy's his mental problems and his emotional issues or how he's done it. It doesn't matter, and people think that sometimes they need to put stuff in there for whatever reason. I don't know. But that anyway. Well, let's keep going here.
Like the evidence in the New York case.
Yeah, exactly. Now, if you take out,
true,
and I mean, there's other stuff they haven't even got into yet that's problematic in the warrant. But this is just, did the cop lie? And it's just requesting an evidentiary hearing. Say, let's have an evidence. Let's put the cop on the stand. Let's get the evidence and let's see what happened. Did he lie or not, Judge? You get to assess him.
Well, Barnes has already said he lied. So now you're going to put it up for an evidentiary. Okay.
You're here every day. He grants him that hearing. If you're a prosecutor, you look at this file. There's no way you let that dimwit get up on the stand. You let a cop that's so dumb he lied about stuff they could prove with things that were sent in the mail, never in writing, always in cash. This cop clearly forgot that lesson. It's amazing. Corrupt cops love to print. They write this stuff. They put it in emails and other communication. They're just because they convince themselves of their fraud and their lies.
Look, I will say this. It's hard to argue with Barnes on this aspect, okay? Just saying.
You've got a completely crooked cop here. And you've got multiple crooked cops because there were other crooked cops at the scene doing illegal things. So you...
as a libertarian, hardcore libertarian, yeah, I get it. But you don't get it. Try that in court, Judge Robert Barnes. Go up in there and say, this guy got a warrant signed by a judge, and these guys are all criminals for executing this warrant. It's just not going to be the case. Oh, sorry.
multiple levels of crooked cops. And someone's going to convince me it's a total coincidence that the person being targeted is one of the biggest critics of the local law enforcement community?
I don't know.
I mean, what world do you people live in?
I don't know. Does anybody watch him anymore?
You don't have to believe in tentacular conspiracies. They saw an opportunity to screw somebody that had been a pain in their rear, and they decided to do so. It's simple as math.
We should probably do an analysis of that, right? Which is, okay, he's online talking on YouTube, talking about the county, the small little shithole in the Minnesota. Is anybody in that town taking his concerns seriously? Is it anything more than just him rabble-rousing on a drunk stream? I would tend to believe that the reach that Barnes thinks that Nick Rekieta had during this is bullshit, and it's not as far-reaching as he thinks it is. That's my
live in Vegas.
We're almost done here.
In Vegas. I don't want these boys knocking on my door, so I'm careful where I come out. I parachute in like a mercenary, and I get back to my Swiss mountains.
No one in Vegas cares a shit about
clear that this has crooked cops written all over it. And if you're a smart prosecutor, do you let that crooked cop be an idiot, take the stand? God knows what dumb lie he's going to make up. This guy was dumb enough to lie about things there's written proof of. So if you're a smart prosecutor, you get out of this case now. You finish this, conclude this, write this up. But I don't know if they're smart enough, so we might get to see these crooked cop embarrass himself right on the stand.
Okay, there we go. That was rough. That was rough to watch. Okay, maybe I'll start from the bottom here and go. I detest government overreach, but the law is the law. No one cares about Barnes and Carter. Yeah, no one cares about him. No parachute strong enough. So I would just say, I personally, I'm not for, especially like gun issue, drugs, all these things. Those are problematic. What my issue though with a lot of this, we try to take it from where the law is and give you an understanding of where people are going to be, where the problems are. Me personally, where I like a lot of personal freedom, but I'm also big into shaming people for doing the wrong thing because I think that's the way you go about it in a libertarian society. With this in mind, it's like, yeah, Nick's a piece of shit. I don't know the guns. I don't like these laws, right? I don't think that, but it's also like, I don't know what you're doing in your house with cocaine and kids around and dirty place if guns are just out and about, right? My guns are locked up right there. It's literally in a pillbox on the floor right now in a case. At least one of them is. And that's the way I feel about it. But I'm going to tell you how the law predicts all this. Okay. Yep. Those cops, after hearing reports about the children being in danger, then forced Nick to drive under the influence, then planted a bunch of cocaine, insisted the ball, and then arrested him. Yeah. A lot of that problem you have there. Okay. Would a gay man dress this way? Barnes. JC is the king of that. Sped up Barnes sounds like he got it to Nick's booger sugar, right? If they want a warrant for drugs, find a dead body, they can't address the dead body. Robert Barnes. Yeah, that's your typical thing. And maybe I'll go real quick and then we'll be done here about plain view doctrine. We'll just go here. I'm finding this shit. I mean, plain view doctrine is an exception in the Fourth Amendment's warrant requirement that allows an officer to seize evidence and contraband found in plain view during a lawful observation. The doctrine is also regularly used by Transportation Security Authority, TSA, officers while screening people. The plain view doctrine applies for discoveries in a three-prong Horton test, which was a case Horton v. I'm trying to see it here, if I can find it here. Horton v. California, 1990 Supreme Court case, which held that the Fourth Amendment does not prohibit the warrantless seizure of evidence, which is in plain view. The discovery of the evidence does not have to be inadvertent, although that is a characteristic. Okay, here's the three prongs. An officer is lawfully present at the place where the evidence can be plainly viewed. Okay. Obviously, if they quash the warrant, this is not going to be in there lawfully and everything gets thrown out and we'll see ya. If the warrant is good, then he was lawfully there. He executed the warrant. It sounds like they tried to get in correctly. Nick said, fuck you. And they busted on the door. All that's good. That three prong, you check it off. All three of these have to be the case or you can't proceed. 2, the officer has a lawful right to access to the object. That's part of the problem you have with, was it in plain? Okay, wait. The officer present at the place where the evidence can be plainly. Okay, wait. Maybe I read this run wrong order. Number one, the officer is lawfully present at the place where the evidence can be plainly viewed. That's what we said. The officer has a lawful right to access the object. In other words, I think one of the cases here, it might have been in this Minnesota case here, talked about. No, that's not the one. It was one that didn't apply, which is officers outside the house of someone, has a warrant, or he's there. He sees something in the house, drugs, through the window, then goes in. No, you can't, because you weren't okay to be in the house itself. This one, a warrant to be in the house, that's lawfully okay. Now, does the officer have a lawful right to access the object? In other words, did the warrant indicate you can be looking? Well, it's for looking for drugs, so likely yes. Last one, this is one, the kind of the crux of this for the guns, right? This would be the nexus. The incriminating character of the object is immediately apparent. Okay, I'm sorry. Officers likely know you can't have drugs and guns together. Maybe a dumb law, I think so, right? But that's what it would have. So there you go. The plain view doctrine was articulated first in the case of Coolidge v. New Hampshire. The original formulation included 3 factors. First, the officer must be lawfully present. We talked about that. Second, the officer must be immediately, without further search, have probable cause to believe that the item is either contraband or evidence of the crime. Third, the opposition must be inadvertent, not anticipated or intended by the officer. That was in that case. However, in Horton, we switched it up a bit. The court eliminated the requirement that the discovery of evidence in plain view be inadvertent. Okay, so it doesn't have to be inadvertent, which has caused ambiguity. The case involved the plain view seizure of weapons related to a robbery, even though the warrant was signed by a judge who had specifically denied permission to seize weapons as part of the search. Interesting. A weapons thing specific on that. Horton ruling also clarified that the officer must have a lawful right to access to the objects to seize them under the plain view doctrine. For example, an officer who sees contraband in plain view in someone's home through a window is not authorized to enter the home, cannot rely on the plain view doctrine to enter the home. Limitations. For a law enforcement officer to legally seize an item, the officer must have probable cause. We've talked about that. To believe that the item of evidence or crime is contraband. The police may not move objects in order to obtain a better view, and the officer may not be in a lawful location. Limitations of Arizona v. Hicks. That one was, I think that case was officers patting down someone. He thinks he has rock cocaine in his pocket. He keeps manipulating it until it is. And then he pulls out and he's like, no, you can't do it that way. Let's see what else issues we have. Sub-doctrines, okay? And plain view doctrine has also been expanded to include the sub-doctrines of plain feel. Oh, that's what it was. That's the Minnesota v. Dickerson. It must be immediately apparent. I'm sorry, you see a gun. They saw a gun shell, right? That was immediately apparent. I don't know if I would need to see more of the actual warrant or the application of the warrant, not the application of the warrant, but the actual search warrant, the search of the house description to see if they found the guns in plain view or not. That needs to be in there, right? Otherwise, he has a good chance of that. Supreme Court held additional inspection was not covered. You're not lifting up stuff unless you're saying, hey, I'm looking for drugs and I'm looking, because that's where you're at. If you're there to look at digital evidence, as an example, child porn on someone's computer, and now you're looking under their bed and you see that there is a gun there, okay, that's you're not looking in the place you expected. But we're talking about cocaine. Where do you typically hide cocaine, folks? That's the question. Okay. Where else we got? I think that's really all we have. Whew, that was a lot. took a little bit out of me, and I hope let's see. Let's go for some here. I can't believe the police are corrupt. They actually found a whole lot more coke, but they took everything above the bare minimum for a felony. Yeah, it sounds racist to me, against the human race. I'm in Texas. Okay, I'm Australian. Glad you guys are saying that. Who's an Australian? Mark Gatto. I'm Australian. All my guns are digital. Oh, welcome from down under. My guns are laying right beside my chair, kitchen, in the back door under my pillow. I carry all times I'm out of the house. Good for you. By the way, I mean, I have, the youngest now is 18, we're up to 24. The boys definitely shoot. The girls have shot. They don't shoot very much. But part of my teaching the kids and growing up with them was to have them shoot and use a gun. And the reason being is because, you never know when there's some crazy shit going on and someone brings a gun. My kids know how to handle weapons. Okay. They know how to, they know the danger. You fire a gun, you're immediately like, oh shit, this is powerful. So when you know that and understand the power in a gun like that, you tend to know how to take care. Well, my kids know how to take care of that. If they were to come upon one, they would know how to unload the gun, take it, disassemble, or what do you need to do to make sure it's safe. It's just what it is, because they're not dumb, right? They're good kids and they shoot a lot. So it's in their nature. And, you have your house like that as well. I have a friend who has, he's concealed carry. He's got like a thing underneath their kitchen. It's just a magnet, and he has his Smith & Wesson under there. That's awesome. Okay. Before we get out of here, saying that the judge has liquor coming out of her vagina is not good. You know what? Thank you, Richard. That is a great comment, because like I said, there's critiques of judges. I had 2 judges this week. Monday, I had 2 hearings. I went from one courtroom to another one. The first judge, I went at her because I needed to. And I wrote on my piece of paper to my client, I said, let her get mad at me, not you. And so, in other words, shut up. And I went at her, and she did. She got upset at me, but she was unbelievable. She hadn't read anything. It was beyond, I couldn't understand what was happening, but you've got to fight for your client, and you do what you can. So that was frustrating. But what I didn't do was immediately go online and say what her name is and start calling her out. It's the dumbest thing you ever want to do. Unless you're not going to be a practicing attorney, then maybe you do that. We already talked about that one. Okay. I think, if you guys want me to, if they get a warrant for the drugs and find it, okay, we talked about that as well. Nick should have absolutely been charged with child endangerment, and he should not have gotten his kids back. He still can. They can still charge him with that. It's not done and over. All right, people, I think that's good. I hope I got to your chats here. If you did a super chat, which we got one here, Oliver, close off. Kudos. I read your I read your whole name. Sorry about that. I finally got to it. Boss baby goes blah blah blah. Night all. Okay, yeah, we'll see you next time. Have a good one. Good. What is it? What's a holiday? Labor Day, Memorial Day. I don't know what's coming up. But Labor Day, I think that's on Monday. Have a good one. I'm busy. It's 6:40 here. 6:40 now on the West Coast. I'm heading down to the garage to try to put my daughter's fender on her car, and I've been 1 beer in, so hopefully I'll be just fine. Love you all. I hope you guys have a good one. Until next week. See ya.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming, or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. Why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is...
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.